Thanks, Christy. Today we're going to have a presentation on wind energy in Iowa, and I've narrowed the presentation, since we only have an hour, to current issues, and we'll get to those. First, I wanted to talk about just some general statistics. Lots of people don't realize how prevalent wind energy is, and especially how much Iowa is a leader in wind energy. So I just like to go through a few stats to let you know what's going on nationwide, and then I'll narrow it down just to Iowa. Most of my stats are through the end of 2014. Most of the stats have not been updated, but if you want more information, you can go to awea.org. That's the American Wind Energy Association, and they have lots of statistics for each state and nationwide if you want more information. So at the end of 2014, there were nearly 66,000 megawatts of wind energy installed in the United States. Now note that this stat only includes utility scale wind projects. So those are the larger wind projects. And this would not include where, for example, someone puts one wind turbine on their farm or to run their hog confinement, or a community college or a school district or a city puts up one or two turbines. Those are not included in this number. The total U.S. wind power capacity that was under construction at the end of 2014 was almost 13,000 megawatts, or almost 1/5 of the entire total that we've done in all the years leading up to 2014. So 2014 was an incredibly busy year for wind construction and wind projects, with people trying to get projects started or in the ground before the production tax credit expired. At the bottom of the slide, it shows the wind power capacity that was installed in the previous 5 years. And you can see by the stat of when the production tax credit was set to expired. For example, in 2012, we had a huge jump. Then the production tax credit expired. The next year was lower while people were gearing back up until the credit was extended. And then in 2014, people were still gearing up and starting to put projects on the ground. So those figures at the bottom of the slide include only those that are completely constructed and in operation. And the bottom figures include small wind, which would include those turbines that are just 1 and 2 off projects. The top states in wind, Texas has always been the leader in wind with 14,000 megawatts. I don't think there's any realistic expectation that any other state is going to ever get to the size of Texas as to wind energy. California is second. Iowa was second until a couple of years ago when California leaped ahead of us. And Iowa is just slightly, about 300 megawatts behind California. It's expected that Iowa will move back into second place by the end of 2015, and that will be primarily due to renewable power market access, or RPMA's projects that they've sold to Mid-American for the Macksburg area and Adams County, and Mid-American's projects with Invenergy up in O'Brien and Osceola counties in Iowa. And the one in O'Brien and Osceola County is the largest wind project that we've ever had in Iowa. And that should be online, or mostly online, by the end of this year, which will leapfrog us into second place, because Mid-American's projects that it's currently working on are about 1,050 megawatts, so that'll make us easily exceed California's current capacity. Oklahoma's behind, Illinois. Those are relatively newcomers to the top 5 in the last 2 or 3 years. The next slide is from the American Wind Energy Association's website, and it just gives graphically what was shown on the last slide that gives you the stats for most of the states in the nation. And this is current as of the end of 2014. The darker the coloring on the slide, the more wind that has been installed in that state. So that just graphically shows you can see the top 5 states and see where wind energy is concentrated throughout the U.S. Very little wind in the southeast and a lot more in the northwest parts of the country. The next slide I have is from the Iowa Wind Energy Center. I get asked this all the time when I do presentations. I go all over the state and do presentations to all kinds of groups, just not CLE presentations. I'm currently president of the Iowa Wind Energy Association, so I do presentations all over the state. And one of the questions I'm always asked are, how tall are these things? They look very large when they're out in the field, but it's kind of hard to tell the scope. I'm sure all of you have seen the blades going down the highway where you can see how large the blades are. This slide is a few years old, and it's a little bit hard to tell, but on the right side of the slide is a 2.3 megawatt wind turbine. Now, just the rotor diameter of that turbine is the same height as the Iowa State Capitol. So that's just the blades, the rotor diameter. That doesn't include the large tower structure. So just the rotor diameter is the same height as the Iowa State Capitol. As I said, this is a 2.3 megawatt wind turbine. Most of the turbines that have been installed in the last several years are 2.5 megawatt turbines, so they're even a little bit taller. The turbines on the left side are the ones that were first in Iowa, up near Spirit Lake and Alta, and those are shown there. And as you can see, the turbines have increased greatly in size since they started wind production in Iowa. The next slide is also a few years old and hasn't been updated. This is from the Iowa Wind Energy Center website. That showed at that time, I think this is around 2012 when this information appeared on the Iowa Energy Center website. It showed the concentration of wind projects at that time, and the little gears are where there were wind turbine manufacturing facilities that made some of the components for the wind turbines, and that's where those businesses were located at that time. Now, some of that's changed. There are a few more businesses, and a few are no longer in business, but it showed the concentration of where the manufacturing facilities in Iowa are located, which have thousands of jobs in Iowa. Now we'll talk a little bit about Iowa specifically. Some wind energy facts about Iowa. This was also on one of the first slides. We have nearly 6,000 installed megawatts, which puts us number 3 in the nation. A more interesting statistic is nearly 28% of all electricity produced in Iowa comes from wind. Now, that doesn't mean that every wind turbine that turns in Iowa, that electricity ends up in Iowa homes, but that's the amount of electricity that's produced, that it could replace 28% of all our electricity. Now, a lot of it's shipped on the lines, to the East Coast, where more electricity capacity is needed. Iowa has the 7th best wind resource in the nation. And if we maximized our wind generation potential, that would be over 570,000 megawatts, which of course wouldn't fit in with our current agricultural structure and with our metropolitan areas, but that's what capacity we could have, and we have 5,600. There's about 1.3 million average size homes powered by Iowa wind. Some of the economic impacts that wind projects have been very beneficial to, especially a lot of the rural areas. Most of these projects are located out in rural and agricultural areas that don't have a huge tax base, and any additional revenue or improvements that can be put in these counties are usually well received and add to the tax base. Currently, Iowa is number 3 in the nation for wind-related jobs at 6,000 to 7,000. Now, this would include everything from people that work in the manufacturing facilities, attorneys like me that work on wind projects, the developers, all their staff, people that do environmental studies, construct the wind farms, and do operations and maintenance on the turbines after the wind farms are constructed. About $10 billion in capital has been invested in Iowa and wind. This will greatly go up. This slide's a little bit old, but Mid-American's investment for the 1,050 megawatts was the largest capital investment ever in a project in Iowa. So that's going to up that, I think, by $1 billion or so at least. The property tax valuation number has greatly increased too, since it's $2 billion. That's the last one I can get definite stats for, but that's a 3 or 4-year-old stat. And property tax increase, we have a project in one county in north central Iowa where the county was very pleased after the wind project was built. It added so much tax revenue to their tax base. Note where it says $16 million in annual land lease payments. These are the payments that are made to the farmers or owners that have wind facilities on their land or in their intimate agreements, such as for wind non-obstruction or other types of agreements. This number is a little bit outdated too. I did some quick calculations today, and I think that number's closer to 18 million, and it's probably even higher with the installed capacity we have as of right now. So that'll increase by another probably 15% at the end of this year. So that 18 million number will increase by another 10 to 12% probably by the end of this year. Environmental impacts, now these come into place if you calculate wind energy savings over other traditional methods of energy production. It's estimated that about 3 billion gallons of water are saved in Iowa every year due to wind production, less carbon dioxide. And another stat that people ask me all the time is how much electricity do one of these turbines produce? A lot of the turbines that are installed now are 2.5 megawatt turbines. That's kind of the standard. And if you have 1 megawatt of power, can power approximately 300 homes. So a 2.5 megawatt turbine can power about 750 homes. Now Mid-American's project with their 1,050 megawatts, that will power the equivalent of the energy needed for 317,000 homes. So it's a big industry in Iowa, and you can see where that 28% capacity of energy produced in Iowa really adds up. So those are the Iowa-specific facts. Now I'm going to talk a little bit about current issues in the attorneys that would need to know if they're working on wind projects or interested in wind projects, either by representing farmers, developers, investors, lenders. And so I want to go through some of these things. I'm not going to do an exhaustive list of everything you need to consider for a wind project, but I'm just going to focus on a couple things. The first category I'm going to focus on are environmental and wildlife concerns. This has become a huge concern for developers and landowners, environmentalists, and everybody in the country due to some of our climate issues. One of the things a client told me recently, and he just, when he found out I was doing the CLE today, he texted me this morning and he wanted me to make sure that everybody knew that some of the proposed U.S. Fish and Wildlife regulations are basically, if they're put into place, are going to end wind energy. Because if the regulations are put into place, it will make almost every site unavailable to have a wind project. The scope of some of these regulations is so extreme that it will be virtually impossible to put a wind project anywhere. So you may want to look into that and comment to your legislators if that's something of interest to you. But this developer's had several projects that they've had to move, relocate, or abandon just because of these regulations that might go into effect. And the current regulations have a pretty good impact on where you can place a wind project, and good developers don't want to have an environmental impact that's adverse either, so they actively, even without the regulations, try to stay away from areas where it'll affect environmental issues and wildlife. Couple of resources for further information, and this is on the handout that the bar sent prior to the CLE. First one is the U.S. Fish and Wildlife Service Land-Based Wind Energy Guidelines. And if you just do a Google for that, you can get those guidelines online, and they'll give you some good information on what the U.S. Fish and Wildlife Service says are good guidelines for environmentally safe wind projects. A more local resource is called the Wind Energy and Wildlife Resource Management in Iowa, Avoiding Potential Conflicts. And this is on the Iowa DNR website. If you just Google that title, it'll come right up for you. And those are some Iowa-specific guidelines that the DNR has put together to help guide people that want to do wind projects into how to do them that are environmentally and wildlife sensitive. Most of the items on the DNR's list, and I have those listed on this slide and I believe the next slide, are pretty self-explanatory and mostly just common sense. The first one is you don't want to place turbines where there are specific species of fish or wildlife that are protected under the Federal Endangered Species Act. Wherever you know those are, you don't put a wind project there. And federal law prohibits you from putting wind projects in that area, but just to avoid those in the first place will save the developer time and money. Also, it's common sense. You put turbines, you don't put turbines near where there are recognized bird concentration areas or migration pathways. There are certain pathways that are known, and I'll talk a little bit later about a map on the DNR website that shows some of those items. You just don't plan to put a wind project there. Also, you should try to avoid putting wind turbines near where bats hibernate, breed, or have colonies, and try to avoid their feeding areas. This is one area where the federal regulations are pretty broad. We had a client that wanted to put a wind project on a certain location in Iowa, and when they did their environmental due diligence, which I'll talk about again a little bit later in the presentation, when they did their studies, there were some areas that were noted by the environmental studies as potential habitats for Indiana bats. There had never been evidence that an Indiana bat had ever been near this area or might even come to this area, but the area was such that the conditions were favorable for that. So they had to work to move their project a little bit away from that, and that's part of what I'm talking about is kind of the far-reaching scope that maybe this wasn't necessary to protect the Indiana bat since they had never been there. But the developers have to deal with the regulations that they've been given. You don't put turbines in close proximity to one another, and because that can affect, there's lots of reasons you don't do that. Most of them are economical, because if you put the turbines too close to each other, there's weight interference, and they aren't as efficient as they would be if set farther apart. And that's part of the reason they're put in lines as well, one of the reasons. But you try to put the lines of the turbines perpendicular to the paths you know that birds will migrate, typically north to south. So you just try to avoid those paths in the first place, and by the placement of turbines, keeping them a little bit farther apart and trying to make them so the bird migration is effective as little as possible. That can help reduce bird collisions into turbines, which is an issue. It's not as much as it was. Early wind projects in California, which are a lot of the information that's been, that a lot of people still see about the bird studies, a lot of those projects were early in California, and there were a lot of bird deaths because the turbines weren't built correctly, they weren't placed correctly, and now we know a lot more about that. For example, placing the turbines in a certain way and in certain places, and the design of the turbines has changed to help reduce that as well. One of the other items, and a lot of our wind developers have started putting this into the wind farm easements with farmers, you reduce the availability of carrion, which are dead birds, dead animals, and if you can reduce that, you know, those animals attract hawks and eagles and other predators to come where the dead animals are located. So if you don't have those dead animals there in the first place, the birds won't be as likely to be attracted to those areas. So as I said, a lot of our developers are putting a provision into their agreements that says if a farmer has, you know, dead livestock, that they can't let them lie around, which they're not permitted to under Iowa law anyway, but they have to remove those, cover them up, or do something with them according to law as soon as possible to avoid birds being attracted to those areas, which will help reduce collisions into the turbines. Another area that most wind developers already do in Iowa is you put wind turbines in areas already fully developed for agriculture, which makes sense. So if you're putting wind turbines out in the middle of a cornfield or a bean field, those are unlikely bird and animal habitats because they're tilled up every year, they don't have a lot of ground cover, and so those are better areas for a lot of reasons. Because of the open space, because farming can easily be done around most wind projects, so that's part of the reason to put wind turbines in areas that are developed for agriculture. If you do have habitat losses or areas that you have to mitigate, the developer will try to mitigate by choosing land far away from the wind project, which will help to attract birds, animals, and other wildlife away from the wind project to these areas where the mitigation occurs. Lots of developers put these areas next to already known habitats and either enhance those areas or enlarge them so they'll increasingly attract more birds and wildlife, which of course will lessen the likelihood of birds and animals being in the wind farm itself. Also avoid certain areas that are known for wildlife breeding and migrating activities for lots of reasons, for environmental reasons and for aesthetic reasons. And also, where you have a lot of turbines or a lot of projects, that can multiply the effects to wildlife, so that's something that developers consider as well. Lots of those reasons are for economic reasons due to transmission capability, and also for wake interference and efficiencies of the turbines as well. There is a map of Iowa that shows particular areas of concern for adverse effects of wind turbines on wildlife, and that's on the DNR website. That's on there, and it's a very general map. It's not very detailed, so no developers rely solely on this map. They do lots of environmental studies, but this is a good place to start to at least see certain areas where you certainly would not want to put a wind project, or that would not be allowed anyway because of the environmental impacts. So that's a good map to start with. So, in addition to looking at the guidelines that are set forth in the DNR guidelines and the federal guidelines, some of the things that developers do when they're looking at a wind project is they do several environmental studies and wildlife studies that can help them determine whether there are bird, bat, other animal habitats, if there are environmental issues with the land, the structure of the land, and what impact the project might have. Most developers plan meetings early on with the DNR and U.S. Fish and Wildlife and other applicable agencies early on in the process. Developing a wind project is very expensive, so they want to know up front if they're in an area that might not be a good area to put a wind project, because that'll save them a lot of money in the future. Also, working with these agencies in advance and letting them know what your plans are strengthens the relationships and develops a better working relationship when you have to go to them with causes or concerns or mitigation. All developers that I work with do a phase 1 environmental risk assessment. You have to do this if your project is located on federally protected lands or lands owned by the federal government. But all developers I know do this anyway, and that just evaluates potential adverse environmental impacts of the project. All developers I know also do a phase 1 avian risk assessment, and that also might include bat assessments. This is one of the ways this is done is people actually visit the site and sit and count the birds and look at the nests and do counts during different times of the year to figure out when the birds migrate there, when they hatch, and what areas might need to be protected. All the developers I work with also do cultural and biological review. They do an archaeological site assessment as well to make sure that if they start digging up on the project, they're likely not going to find any Indian artifacts or other artifacts from old schoolhouses or historically significant sites. They do that in advance as well to lessen the risk of that. They also review all the guidance and work to comply with the guidelines. One of the things that all the developers do is a wetlands delineation report for the project site. Now, the wetlands delineation is likely not to show much because wind projects typically are not located in areas where there are a lot of wetlands, because wind projects are usually on higher lands. But if there are wetlands in the project, they have to determine whether the wetlands will be affected and if they need certain permits or mitigation to be able to put the project in those areas. Once the project is built, that doesn't stop the obligations of the developer or owner of the project to do environmental monitoring. They have to monitor how many birds are killed, effects on habitats. If anything was determined in the preliminary studies, those might need monitoring as well. But good developers do this throughout the project to make sure that any adverse impacts can be dealt with by, maybe doing something a little bit differently. Also, part of the due diligence, of course, is complying with all the environmental laws and regs as well. The second category, in addition to the environmental impacts of wind projects that I'm going to talk about, are the wind energy agreements that most developers enter into with the owners of the land, where there will be wind project improvements or land that they want to protect from having another wind project coming in by getting a wind non-obstruction easement from the landowner. So I'm going to talk about some of the terms, and hopefully this will be of interest to a lot of the practitioners on the line that have a client bring a wind easement or a wind option agreement into their office that they might not have seen a document like this before. That'll help you go through some of the provisions and know what to look for, and maybe why some of those provisions the developer wants and what the reasons are for that. The wind farm easements that we draft are very lengthy agreements, usually 30 to 40 pages. They're very complex, include lots of protections for the developer, protections for a lender on the project or a purchaser, and also some protections for the landowner as well. So if you're presented with one of these agreements, you really want to review it carefully, especially if you're reviewing for a landowner, to make sure that the impact on their land and what they want to do with their land is affected, that they can still do what they want with their land within reason without violating the agreement. The first document we'll talk about are option agreements. Some developers do a separate option agreement where they take an option over a certain portion of the landowner's land for a period of perhaps 3 to 5 years that gives them an option to have the landowner and the developer enter into a long-term easement agreement if the developer figures out that the project is viable, that they want to enter into a long-term easement with the landowners involved in the project. Typically, these are 3 to 5 years in length, which sounds like a long time, but it takes a lot of time to do all the due diligence to put a wind project together. Could be hundreds or thousands of acres of land that need to be included in the wind project, which means you might be dealing with hundreds of separate landowners, hundreds of title issues, the environmental studies, the survey work, is all compounded when exponentially the more land you add to a wind project. So it can take a lot of time. And remember, you have to have contiguous properties for a wind project, so it takes time to figure out if you're going to have enough properties that are contiguous and continuous that you can do the project. Some developers, as I stated, do a separate option agreement where they can exercise the option at some point in the future and have the landowner enter into a long-term easement agreement. We're finding more commonly what developers do is they incorporate the option period, usually it's called an evaluation period or development period, into the easement agreement itself. And this gives the developer a lot of the same protections where they have maybe 2 to 3 years to get the project put together before they pull the trigger on the actual easement terms of the wind project, which would be the long-term agreement between the landowner and the developer. So you might see one of either of those options if you're looking at an option agreement or a wind farm easement with an option language incorporated into it. Option agreements have different compensation terms, and you'll want to look those over carefully. Some developers do an option payment, which is just a flat fee, for example, $500 for an option. Some do on a per acre basis, maybe $10 an acre, where they pay the landowner $10 an acre for all the option acres. So you'll want to review that to see what effect that will have on your landowner's compensation. Also, a lot of the option agreements have an extension period where the developer can renew the option or the evaluation period for an additional year or two for some additional consideration. So you'll want to look at the option agreements carefully. The developers that we represent that use option agreements also attach an exhibit to the option agreements that has a list of the types of terms, the general terms that will be included in the easement agreement, including what the landowner will get compensated, how long the easement term is, kind of all the important terms that the landowner wants to know. So you'll want to look over any exhibits carefully as well to make sure if your landowner enters into these types of, into an option that eventually requires them to enter into an easement agreement, you'll want to know what terms that easement agreement will be on. So that they know what they're getting into from the outset. Now I'll talk about the easement agreement. Most of the developers we work with use easement agreements rather than leases. Some people use the terms interchangeably, but easements and leases are two different things that give different rights. Now, typically, if I draft a wind farm easement, the actual language in it, some of the provisions are more like a lease, some of the provisions are more like an easement. So even though a wind energy lease is called a lease or an easement, the actual terms in it probably are a combination of both. Every wind easement I've seen has some language that you could say, really, this looks like a lease or it looks like an easement. The first thing the developer has to consider is who has to sign the agreement. Well, all of you that are real estate practitioners know the answer is everybody that has an interest in the property has to sign the easement agreement. And that would include spouses if an individual owns the property. How do you figure out who owns the property or who has an interest in the property so you know who to sign the agreement? This can be done in a lot of different ways. It can be done by getting abstracts updated for the landowner's property. It can be done by getting title commitments from a title insurer, getting a title certificate from the local abstractor that just says what the legal description is and the current title holders. It would be really nice to use abstracts for this, but most landowners don't want to give up their abstract, and most of these projects are in local counties that may have one abstractor, and for a large wind project, it may mean taking 100 abstractors to this abstractor that need updated in a short period of time, and then, of course, 100 title opinions would have to be issued. This isn't really practical for larger scale wind projects. It is practical, for example, for if you're putting a turbine on one or two turbines or just a handful, that might be okay. Lenders for wind projects, however, are going to require that you have title guarantee or title insurance. So we've found, even though I'm a real estate practitioner and firmly believe in Iowa's abstract system and don't want to see that go away, for wind projects, title insurance is usually the practical route to go. So that's how we determine who must sign the easement agreement, and then we draft those documents accordingly to make sure that everybody signs that needs to sign. The term of the easement agreement. If you're a practitioner representing the landowner, you'll want to know how long does this agreement tie up their land. From the developer's perspective, the term of the easement has to be long enough for the developer to recoup their costs and to make a profit. Wind turbines are estimated, and nobody really knows for sure because projects haven't been in the ground for 20 or 25 years. They're expected to have a life of about 25 years. So that's usually about how long the initial term of the wind farm easement is, 25 to 30 years. Most wind farm easements have an option where the developer, the owner of the project, can renew the easement term for an additional 10 years or maybe 2 additional 10-year periods. And when you look at that for the renewal term, you'll want to see how the landowner is going to be compensated for the renewal terms. And to make sure that the compensation, you'll want to know whether the compensation gets adjusted according to inflation, to market terms at that time, or if there is any adjustment to the compensation. The next item you want to look at, and one thing the developer has to decide, is how much land of the landowner's land should they include in the agreement. A lot of developers take an easement over the entirety of a landowner's land. So if a landowner owns 40 acres, they take an easement over the whole thing, which gives them rights to do things over the entirety of that 40 acres. Usually that's objectionable to the landowner, so most developers now, they may take an initial option over the 40 acres, but then when it comes down to the easement agreement, what they generally do is set out specific easements, either by including a drawing and eventually an as-built survey that shows the location of the certain easements on the landowner's property. For example, you might have half an acre taken out of that 40 acres to put the turbine on. You may have, for the actual turbine foundation. You may have additional land for electric lines that are going underground or for access roads. So those are the areas where the landowner can't, for example, farm the land, because those improvements are in the way. Then the developer will keep an easement over the remainder of the 40 acres for wind non-obstruction, as a noise easement, shadow flicker, and on the rest of this land, the farmer can farm it basically as they did before if it's farmland, just that they can't build a really high structure or build more wind turbines or do anything that would affect the operation of the wind farm. Usually they can build smaller structures, and it has to be pretty high structure to actually affect the wind project. You'll want to look at that and see what the landowners can use the rest of their land for. One of the developers I use after the project's built, they have an as-built survey done, and then that replaces their preliminary drawings, and those are recorded to show where the actual impacts and actual easements are exactly located on the landowner's property. A lot of the easement agreement will have the various easements, types of easements that are on the landowner's property and how they affect the property. This slide shows a list of the typical easements that we have in wind projects. You'll likely see most or all of these. The Met Tower is one that may not be included in the agreement because typically a Met Tower is only located maybe one or two in a project. Unless it's large, there could be 3 or 4. But not every property will be subject to that, so that might be an easement that's left out of some or all of the landowner's agreements. Lots of developers enter into a separate Met Tower license or agreement with the landowner, so the Met Tower language may not even be included at all in an easement you're looking at. The first easement is a construction easement, and it gives the developer the rights, exactly what you would expect, the rights to construct, erect, install, repair, maintain the wind facilities on the property. And usually the construction easement also gives the developer the right to go across the landowner's property with cranes during construction. This is extremely important that the developer have this right to go from property to property when they're building the wind improvements, because it's extremely expensive to erect a crane and then have to unassemble it and then reassemble it a quarter mile away or half a mile away, whatever. We've been told it costs $100,000 to have a crane taken down and put back up if they have to move it a mile. So it's very, very important that the developer have this right to move from property to property. The next easement I'll talk about is a turbine site easement. This is where the actual turbine sits, and so that's what's included in the turbine easement. Usually a landowner it'll encompass more area, it'll encompass where the blades are above as well, not just where the actual foundation sits. And usually the landowner can farm the turbine site area up pretty close to the turbine. They just can't go where the improvements are located. Access easement allows the developer access to the property for construction, to exercise the rights under the easement, such as repairing wind turbines, maintaining them, and usually the rights are given along access roads. There's hard gravel roads that go from turbine to turbine in a wind project, and the developer will use those, but the document will usually give them the right in the case of emergency to cross the landowner's property in anywhere they want, or if they can't, if using the normal routes would cause more damage to the landowner's crops, things like that. Collection facilities easement, these are for the collection facilities, which are the underground or above ground cables, wires, fiber optic lines, circuits, everything like that. Most of the agreements require them to bury anything at least 48 inches deep. That's kind of the standard. Met Tower easement gives them the right to put a meteorological tower on the property. As I said before, these can be done by separate easement agreements or licenses, and there's usually only 1 or 2 or 3 maybe in a project, so you may not see this very often. An overhang easement. This allows, turbines are lots of times put close to property lines, so if I have a wind turbine on my property and you live next door, the blades of the turbine probably are going to overhang your property. and that gives the developer the right to overhang the blades over your property. So if you don't have a turbine on your property, you still might need to have an overhang easement, which allow the blades to be over your property. This easement usually also includes a waiver of setback and zoning requirements, because you typically can't put improvements, very close to property lines, and in this easement, the landowner waives that, so that can be done. The wind unobstruction we've talked about a little bit. This is where the developer has the right to the unobstructed flow of wind across your property, so you can't build anything, the landowner can't build anything that will affect that. Noise easements. This is another easement. Wind turbines do make noise. It's usually not objectionable noise, and it's usually not loud noise, but a lot of the county ordinances have a maximum level of noise that the wind turbines can make. So this gives the developer the right to make noise over your property up to those levels. The next easement are light and shadow easements, and this gives the wind farm the right to cast light from FAA lighting, the little red blinking lights you see at the top of the turbines, and also for shadows. When certain times of the year, wind turbines, the blades turning make shadows, and shadow flicker over property. Maybe you've seen that driving on the highway. If you're close to a turbine, you see the shadows. That gives the right for those shadows and the lights to and affect your property. The last easement are study easements, and these give the easements the right to go on for those avian studies, biological studies, phase ones, things like that. What the landowner is usually most interested in is, how much am I going to get paid for this easement? This is something you have to do carefully as well, because all the developers I represent, each one has a different type of payment structure. Some developers do a per megawatt payment to the landowner for turbines, which might be, for example, X dollars per megawatt. So if you have a 2.5 megawatt turbine on your property, you get 2.5 times whatever that per megawatt payment is. Some do a higher per megawatt payment, and that's what you get. Some do additional payments for the linear feet of the collection lines, the access roads, or other improvements. Some do a per acre payment over all your property because it is affected by wind obstruction, so there's different payment schemes. Since these agreements are long-term, one thing you'll also want to look at is, do the payments increase over time? And is it based on CPI? Is it based on some other factor? Is it a flat increase per year? So you'll want to look at that as well. Crop damage compensation is the next area we'll look at. This is important to the landowner because construction is messy for a wind project and takes up a lot of area. Developers try to time the construction where it will have the least impact on a farmer's crop, but of course that isn't always possible. The growing season is also construction season. So you'll want to know how much the landowner will get paid if growing crops are damaged. Usually those provisions will be set out, what the bushel price is, how the bushels are calculated, how the area is calculated. Many developers also give an extra payment if the land is particularly compacted during construction, because it may grow less in the long term if it's extremely compacted. That's usually a one-time payment. Drainage tiles, if there's drainage tiles on the landowner's property, this has to be addressed. Putting the collection lines in and the other improvements through a property may mean that drainage tiles have to be cut and then repaired. Most agreements will include language requiring the developer to fix any drainage tiles that they ruin during construction, that they either break or have to cut through. And after construction, they'll provide the landowner with a map showing where all the collection lines are, so if the landowner wants to do future tiling, they'll be able to do it more safely by knowing where the electrical lines and other improvements are buried. And they'll also want the landowner maybe to provide the developer with tile maps showing where the tile are located so they can avoid that as much as they can. The wind farm easement will require both parties to make reps and warranties. Some of the landowner's reps and warranties are that they actually own the land and have the rights to grant the easement, to identify liens on the property, especially if they're unrecorded, such as name the tenant, because most farm leases are not recorded, require the landowner to cooperate and cooperate with zoning, and to indemnify the developer to the extent that any damages or injuries are caused by the landowner's activities on the property. This doesn't sound like much of an issue, but there are some projects where landowners have allowed hunting on the property, and people working on the turbines have been injured while other people are hunting on the property. So that's a possibility that you'll want to be aware of as well. The last three items we'll talk about, since we have a few minutes left, are assignability. Typically, the wind farm easements are assignable by the landowner, that they can freely assign the agreement and to a future landowner, whatever, and that's not going to impact the easement. Of course, the new landowner or the assignee would take subject to the wind farm easement. If the landowner sells a property, if the wind farm easement is of record and provides the appropriate notice, then the future owner would take subject to the wind farm easement. Usually the developer can assign the agreement to a project entity, or it would be allowed for the developer to assign the wind farm easement to a lender if that became necessary. There's also lots of provisions for lenders that protect lenders, that allow the lender to step in if the developer isn't making payments, and to protect the lender. A lot of the wind farms are very expensive, so a lot of them have to rely on loans. So a lot of the protections you see in the wind farm easement are, even if it's not in the lender section, are actually meant to protect the lenders and are required by the lenders before they'll loan on the project. Decommissioning, this is important to both parties. What happens if 25 or 30 years down the road, the wind farm project isn't running anymore, or they decide not to repower it after the end of 25 years or the useful life of the turbines? Most easement agreements require the developer or the owner at that time to remove all the wind farm improvements whenever the easement term ends or the project is no longer used within 12 months. And they have to remove everything to around 48 inches, everything that was underground. If the project owner doesn't do it during that time, the landowner can remove the improvements themselves. And we've had some estimates where the removal of the wind project, the salvage value of the turbine components should equal the cost of removal. Lots of county ordinances make the project owner put up a bond or some type of other security to secure the removal of the project. And usually these, either bonds or some other security that has to be put up, is started to be put up in year 10 to 12 of the project. That's typically when a lot of the lending has been paid off, and the developer may have additional funds that they can devote to that. Funds are put into an account that's set aside, so if the developer doesn't fulfill the removal obligations, there are funds there to do that. And a lot of the county ordinances include that. And I think I misspoke. It's usually about 15 to 20 years after the project's built, somewhere around that year 15 that the security has to start to be posted. Confidentiality, a lot of wind farm agreements say that neither party can disclose the financial terms and have to keep it confidential. That's one of the terms you may see. And one term that wasn't on the list that I thought of this morning are lots of the wind farm easements include a most favorable terms clause. And what that means is the developer agrees to not enter into an agreement with any other landowner with more favorable terms, at least the financial terms, than they enter into with you or the initial landowners. These types of provisions usually serve to protect both parties. If a landowner signs up early and really wants the wind project, then they're protected from somebody that signs up 3 months from now that the developer really needs. The developer can't pay that person that signs later more money to get on their property. If they do, they have to go back and give the first landowner that same compensation terms. So that helps protect people that sign on early from, getting the shaft if the developer really wants another property, they just can't pay more for it, or give that landowner more favorable terms. Second, it also protects the developer, because people that hold out know they're not going to get anything more than the early ones did, so they're more likely to sign up sooner, which helps cut costs and get the project put together more quickly. That's the end of the presentation. If anybody has any questions, please go ahead and post them now. There's a space if you have your screen up where you can type in a question. If you have any questions for me, you can type those in now, and I'll be happy to address those.
If you have a question, please remember you can use that chat box feature to type in your question. It looks like we have one right now.
Okay, we do have a question, and thanks for asking that. The person asking the question wants to know how many wind turbines can you put on a section of land? I get asked this lots of times as well. It may look when you're driving out in the country like there's wind, if you're in a wind project, that they're just everywhere. It used to be that the rule of thumb was you could put a wind turbine on 40 to 60 acres. Wind turbines have gotten enough larger that the rule of thumb now is that a wind turbine takes up about 160 acres, so that you're usually not more than 4 or 5 wind turbines per section, if that. Thanks for asking the question. Another question is, do shadows and flicker cause many issues? Good developers take care of this a lot from the outset, and a lot of the county zoning regulations help take care of this too. Usually can't put a wind turbine closer than 1,500 feet to a person's house. A lot of the developers try not to put wind turbines within a half mile of an occupied residence. So that solves a lot of those issues. Most of the wind farm easements also require the developer, if there are shadow flicker on a property and it becomes, too much for the landowner to take, that the developer has to plant trees, buy the landowner room darkening shades, or do something to mitigate that to help them. And it's usually only if the shadows do flicker on a property, it's usually only for a week or two a year, because as the sun moves, that's going to change. The developers also do shadow flicker studies while they're planning the project. They can anticipate where the shadows should end up during different times of the year, and they try to avoid placing turbines where that is going to cause an issue. So thanks for the question. We have time for a couple more questions if people are interested. Okay, somebody else asked, can the landowner travel on the easement to harvest crops? As I mentioned before, the wind turbines, there's usually 16 foot or so, at least, wide gravel roads that are put between turbines to turbines. Most of the developers allow the landowner, you can use those to park your wagons on when you're harvesting and go over them. So if you have rows on one side and rows on the other, you can take your combine across those to make a round. So usually most of the agreements allow the farmers to use the access roads. They just can't block them. So if wind personnel need to get there, you could have a wagon there, but you need to move it if for the operations and maintenance people couldn't get by your tractor. So you might have to do that, and you, of course, can't damage the roads. But otherwise, most of the developers really don't care if you can do that. And except for where the actual turbine is located or any other above ground improvements, you usually can use the property as you did before. Okay, another question is, how noisy are wind turbines, and are the easements we discussed usually enough to satisfy the landowners? This is, again, the developers do noise studies before they start. They can predict at certain times of the year how much noise will be emitted by a turbine to anything occupied residences they can calculate that pretty well. So they usually avoid those issues up front by doing good planning and not putting turbines where they could cause a lot of noise. A wind turbine makes the equivalent of it sounds kind of like a refrigerator running, but that's kind of the equivalent of the sound that's emitted. So if you're standing close to a wind turbine, that's the decibel level. A lot of the ordinances won't let you go, I think it's about 55 decibels on a landowner's property. So if it goes higher than that, you have to figure out you can't do that. Usually they don't put turbines close to houses for that reason. We have one developer who had a house in the middle of a wind project, and he had 4 or 5 turbines, close to his house, but not really close. I mean, the permitted distance. When you sit on his deck at night, you really can't. I mean, you can hear the whoosh of the turbines, but most people don't find it annoying anyway. But a lot of those problems can be fixed up front by just proper planning. Next question is, how does a wind project affect crop farming? The year of construction, it can have a pretty significant impact on crop farming. As I mentioned, the construction can take up, it's large equipment, large cranes. It can really affect 1 year's crop season, depending on when construction takes place and what the extent of construction is on that landowner's property. Usually from then on, the farmer can farm right up to those access roads and right up to the wind turbine within a few feet of the wind turbine and farm the rest of their land normally. It's usually not affected. We have time for 1 or 2 more questions if anybody has any further questions.
If you have any additional questions, you can type them in this time, and I'll remind everybody of the activity ID number where we're waiting to see if there's any more questions. It is 191770. That number again is 191770. We don't have any additional questions. If they have a follow-up question, Kathy, is there an email?
Yeah, if you have follow-up questions, I'm president of the Iowa Wind Energy Association, as I mentioned earlier, and I do lots of wind energy works, about 60 to 70% of my practice. And I have lots of resources. If you have additional questions on anything I talked about or anything else with landowners, you can email me at kkLAW@nyemaster.com. Or you can just, you can look my name up on our firm's website, nyemaster.com, and that'll give you my information. Okay, we have 1 more question. Thank you for attending today while we're looking up this last question. Okay, the last question is, assuming landowners are responsible for decommissioning costs, are you suggesting the cost of decommissioning is completely offset by the salvage value? That's what figures that we've seen. The salvage value of the steel and everything that's in the turbines should equal or be pretty close to what it would cost to remove the turbine from the landowner's property. Those are the figures that we've seen. So that's what we've been told. Okay, another question, what's the average financial difference for the landowner between farming and using it for wind turbines? Well, it's hard to tell with, crop prices and everything have varied so much. A couple of years ago when crop prices were really high, wind energy was less attractive. But you talk about the little bit of land that it takes. It takes, I think, about 2.5 acres at the most average for a turbine site and that area, and you can farm, closer to the turbine than that, so I don't think 2.5 acres would be taken out of production. But I would say a good average for compensation per megawatt is $3,000. That's on the low end, so double that times 2.5, you're looking at $7,500, $8,000 a year for that tiny piece of land that you're giving up where you can't farm. And then you're probably getting additional payments for access roads or for improvements or per acre fee just for agreeing not to put anything else on your property. So landowners can get, up to $10,000, $15,000 a year for just having a turbine or so on their property. So it's a pretty good per acre return when you think of the actual land taken out of production. And then with the increases, we project out for 20 years and provide that to the landowner. One of our developers projects out to 20 years. We have lots of landowners that end up with hundreds of thousands of dollars for over the term of the easement with the increases.